So welcome, everyone. My name is Pam McKillop. I'm here with Allison Daigle. We're the co-directors of the Autism Alliance. We're also joined today, I think Katie Cassavant, our Autism Alliance autism specialist, is also on the video tonight. So join me in welcoming Tom Sanacandro. He's here to discuss the importance of special needs trusts and wills, as well as his website, specialneedstrustsonline.com, which provides an easy and low-cost mechanism to develop the two. So I'm just going to hand it right over to Tom, and he can start the presentation.
Great. Thank you, Pam and Allison. Thank you for inviting me today, and thank you for everybody who's joining us as well. Hopefully you're going to learn something from this presentation. What I'm going to do today is the whole law that I'm going to talk to you about is really not that complicated, but since most people haven't been involved with it, it can seem a little overwhelming. I'm going to try to make this as clear and as direct as possible. What I've learned from doing these webinars like this is it's very helpful for me and everybody else that if you don't understand something or you have a question, if you can ask it while I'm in that particular topic. My challenge is that I've been doing this for so long, I'm not sure when I'm skimming over something I shouldn't, or if everybody needs more information. But know that if you need more information, you're not alone. There's going to be lots of other people that are wishing they asked the same question. So, and it helps us, I think, as we move through, is that if you ask your question as soon as it comes up, it won't interrupt my flow. I really appreciate the question, so I think that would be a great way to handle it. I'm also planning to stop at the end of every, for most slides, so that people can ask a question and we can delve into it a little deeper if we need to. So first off, what we're going to talk about today, first off, I'm going to do a little deeper dive on why you should listen to me, what my qualifications are. And then I'm going to go through the documents that you need. And you've all heard of these documents, wills, powers of attorney, and all that. But I'm going to try to explain them and how they fit together for a family who has a family member with a disability. And then I'm going to talk about the problem. Why do families who have a family member with a disability, why do they need to do something different? What's the purpose of this? Everybody here knows that they should probably do a supplemental needs trust, or otherwise known as a special needs trust, but they may not know exactly why they need to do that. And I'm going to explain that problem, talk about different solutions, and then finally I'm going to walk you through the website. The website is, I have started a nonprofit, 501c3 nonprofit organization that developed a website that provides all these estate planning documents at a super reasonable cost. And it's all done online. It's like LegalZoom or something like that. It's very simple, easy to use. But the difference is you get to set up appointments with me and talk to me directly, either on the phone or through Zoom like we're doing today. So that's the difference. And then any other questions? That's the plan for tonight. And I won't have you ask questions right now. So what are my qualifications? Why am I the guy talking to you tonight? I think the first thing is that I'm a dad. Like many of you, I have, my son has Down syndrome. He's 38 years old, so I've been around the block quite a few times at this point with all sorts of things. But I think that's my number one qualification, is that I really understand what families are thinking about, where their challenges are, the whole process. I'm also a lawyer. I've been practicing for quite a while, to say the least, at this point. I've also been in the legislature, so I've looked at the issues around policy. I've been on local school committees, the whole works. In addition, I'm a researcher. I've been researching and working in the area of adults and children with disabilities in all sorts of ways, mainly around the area of education, but I've also been looking at and examining healthcare, the special healthcare needs for kids as well. And in addition to that, I've been involved with technology and done web design, and that's how we ended up with the website that I'll be introducing you to later on. So this is the beginning of what we really need to talk about tonight. These are every document that you really need and should have. If you have a family member who has a disability, this is what you should have in place. And that's why many of you are here on the line. I'm going to go through each of these documents and we're going to talk about them, but they're the will, the special needs trust, also known as the supplemental needs trust, power of attorney, healthcare proxy, letter of intent, and ABLE account. Some of you know all those terms and know exactly what I'm talking about. Some of these terms may not be as familiar to you. So the first document, I think everybody understands, but you may have some questions about it. The will is the document it's a piece of paper, obviously, that in Massachusetts and most states needs to be written out, needs to be witnessed by 2 witnesses, and also notarized to be so that the court doesn't have to pull it in. It controls the disposition of all your assets. It also names an executor or personal representative, as it's known in Massachusetts, and that's the person who hires the lawyer and carries out your wishes. You may designate a guardian for a minor or for other individuals that need incapacitated adults that may need guardianship. And it's also a way to take advantage of any tax savings.
Hello, do you hear me now?
Yes. Is there a question?
No, I think I just muted her. I think she was.
Okay. Any questions? Let me just stop right here. Any questions about the will? The next is the power of attorney. And what the power of attorney is, it's nominating someone to act for you in your place. Sometimes people will do a power of attorney if you bought a house and you're not able to make it to the closing. Sometimes you appoint someone or issue a power of attorney to someone to actually act in your behalf. What the power of attorney does generally is it allows someone to act for you in your legal capacity in any way that you need. Whether it's going to the bank for you, buying or selling property for you, all sorts of things. That person that you appoint, which is the attorney, it's called the attorney in fact, or the agent that you appoint, you give the power of attorney to, can really do just about anything that you could do for yourself. And I just want to talk about the power of attorney. It is probably the most important document we're going to talk about tonight. More important than the will, the special needs trust, everything else, because once you've issued a power of attorney, whatever you didn't do, someone else can do for you if you're not able to in the future. I've had multiple cases where someone didn't have a power of attorney, then became incapacitated, and then was unable to do things for themselves and actually had to go to court and get guardianships appointed. And it's just so much work and so much legal work that wouldn't have to be done if this very simple document was signed. Let me just stop for a second and hopefully there's some questions about power of attorney. Does everybody completely understand what a power of attorney is? One of the things that you can use with a power of attorney that some people may or may not have thought of, if your child with a disability is someone that's very capable and capable of making their own decisions and capable of doing things on their own. One of the ways that we can empower someone with a disability is not put them under a guardianship when they turn 18, and is to have them issue a power of attorney, usually to their parents, so that they can act for them legally if they need to, or just assist the person with a disability as much as they can. Sorry about that. So, and I'll just use an example from our family. So my son, who has Down syndrome, he's a capable guy. He's able to do a whole lot of things. He does need assistance. But what he did when he turned 18, he issued a power of attorney to us. And we've continually been able to help him with his banking, with Social Security, dealing with all sorts of things, while he retained all legal powers. He's, a few years ago, he moved into his own apartment. He was the person who signed the lease because he's not under a guardianship. But we can continually help him if he needs it. And like a lot of times I'll call, if I'm dealing with his banking or whatever, and they'll say, well, you don't have authority to do that. And I'll say, I have a power of attorney, and I'll just email it over to you. And that's usually how it's handled. It gets emailed over and they say, okay, all right, now we can talk to you. So it's a great vehicle. So not only should you be doing a power of attorney for yourself, nominating someone to act for you, but if you have a child with a disability who's capable of making decisions on their own, just may need some extra support, power of attorney is a great way for them, rather than to use a guardianship, to have them issue a power of attorney to you. And Katie has a question.
She does. Okay, great. Yep. We have
She
another one.
shows up on my screen. that
Okay,
way at
good.
the
And
top.
we
Yeah,
have one
thanks.
after her as well. Okay.
Great.
I was gonna say, yeah, there was a couple in the chat too that I saw, but my question is, if you're the power of attorney of your sibling, are you still allowed to work with them? Like, I have a brother with autism who I work with, like, get paid for. Could I still be his power of attorney also, or is there any legal thing against that? Because I know guardianship there is, so I was just curious.
Right. That's the only thing that I know of is the guardianship. Is that you definitely cannot do it with a guardianship. I don't see how the power of attorney has anything to do with anything, because it's not the same kind of, under a guardianship, you have fiduciary responsibility, so you have responsibility towards that person. What the thinking behind that is that if you have a guardianship, you're already obligated to act for that person, so the government doesn't want to pay you. Power of attorney has no such obligation. They don't have any obligation to act for that person, and to take care of that person. They only have the opportunity to represent them legally. Was I clear enough or no?
Yeah, no, I think that makes sense. It gets a little confusing. And so it sounds like the power of attorney, somebody can have a power of attorney and not have a guardian, and that would be okay also.
Yes.
Okay.
Yes.
This next question is there a downside to power of attorney?
Well, the downside to power of attorney is the way that I draw them, and the way it's actually done on the website is made to make it easy to use, so that if you have that document and you're going to go to the bank or whatever you're going to do, you have the power to do that as soon as the person signs it. That's the good news, because it's really super easy to use and there's no little catch. You don't have to go to court. You don't have to prove anything. You don't need a doctor's note. You get to do it that way. The downside is the same, because it goes into effect immediately. You can do whatever you want for that person. For instance, so I've issued a power of attorney to my wife, and that's typical between married people, that they issue it to the spouse. The way that's issued is that she could, as soon as we sign that, she could go, and if I had bank accounts in my own name, she could go empty them if she wanted to do that. because the power of attorney is that easy to use. There are ways to draft a power of attorney that are called like springing power of attorney that only works when the person is disabled and unable to make decisions for themselves. I typically do not use that power of attorney because then you have to get a doctor's note and you have to prove that the person's disabled, and that can create all sorts of problems of using the power of attorney. So the downside and the upside of the power of attorney are the same factors, just how they play out.
All right, the next question, and the last question for now is curious. What does take advantage of tax savings mean in relation to the will?
So, and I almost took that out of that slide. So what happens is in Massachusetts, if you have an estate over $1 million, you have to pay an estate tax, meaning when you die and your estate is over $1 million, you have to pay an estate tax. Massachusetts is one of the lowest estate tax thresholds in the country. I think there's only nine states that have a lower threshold than 16 million, and we have 1 million. The reality of that 1 million is, though, that if you have a spouse, you can give everything to your spouse for free, essentially, and there's no tax consequences. The challenge is that the second person in the married couple who dies now has a much larger estate that is then going to go to someone else. You can do some tax planning around with a different type of trust than the supplemental needs trust or the special needs trust we're talking about. It gets a little complicated on how that works, but there are ways to do that within the will. Typically, what I advise clients is, my Massachusetts clients, that if you have an estate that's worth about 4 million, you don't need to start thinking about it, even if you live in Massachusetts, unless your estate is about 4 million to 5 million or above. And the hope is that Massachusetts will change that law. They attempted to change it this year. They were going to raise it to 2 million, which would then double my figures that I'm thinking about when I advise clients. I think the reality is my expectation is over the next few years that 1 million threshold will be raised considerably. But if you have a very large estate potentially, it's something to consider, and it's something that when you do an estate plan, you can actually mitigate the taxes you would owe. And hopefully that wasn't too confusing, but that's. Do you have, whoever asked that, do you want to put in a follow-up, or is that satisfy you? We're all good? Perfect. The next document is a healthcare proxy. Probably most people on this call have already issued a healthcare proxy to someone, usually to their spouse. What the healthcare proxy does is it allows your agent to make decisions for you, particularly like if you're unconscious or whatever, someone can make the decision for you. It's a tough place to be because you're making a decision for someone who's appointed you as their healthcare proxy. But without it, that can't happen. Usually if you're going into the hospital or even in your doctor, a lot of doctors' office require it. They'll say, do you have a healthcare proxy? If you say no, they're going to put a form right in front of you right then and say, okay, you got to name someone and sign this document. Or they don't want to be stuck with you. The challenge is to the hospital is if you do not have a power of attorney, healthcare proxy, something happens to you where you can't make a decision yourself, they're going to have to go get a guardianship for you. So they're going to have to go spend money to get lawyers, to go to court, to get a guardianship to make a decision for you when you cannot, if you don't have a healthcare proxy. So again, this is a super important document that everybody should have. Probably many of you that on this call have already issued a healthcare proxy. Some of you may not have even realized you've done it the way it happens so quickly in the doctor's office or in the hospital. But it's a critically important document. Again, this is another document that can be used by your child with a disability. Once they turn 18, it's if they're not going to be under a guardianship, it's really important that they issue you a healthcare proxy so you can help them with their medical decisions, that you can share their medical concerns with their doctor, because the doctor really can't talk to you once they're an adult. They have to make the decisions themselves. They have to do that unless they're under a guardianship. And I'll pause again for questions.
The question from Lisa is, how long does it last?
It lasts until it's revoked. And you can just revoke a healthcare proxy, but yeah, so it lasts forever essentially, until you pass away and there's nothing for you to, yeah. Yeah, so it just, there's no end date to a healthcare proxy. Any other questions on that?
Nope.
This is another important document, the letter of intent. And it's one that I advise my clients a lot on. This is a document that's on the website that's completely free. You can just click on it, enter your email, and you'll get the draft of the letter of intent of what you can fill in. You know, not to be crass, but the way to think of the letter of intent is like an instruction manual for your child who has a disability. Who are that child's doctors? And child is like, can be an adult child as well. I'm just, you know, that's who we're talking about. But it's like an instruction manual, like who are their doctors? Who are their friends? What do they like to do? All those things that if someone has to step in and be involved in helping and supporting your child after you're gone, they have essentially this instruction manual that's going to tell them everything they need to know. The other piece that I think is really important about the letter of intent is that it also is a way to talk about your vision for your child if you're not around, particularly if your child is not verbal and not able to make their wishes or their, you know, what they really vision for their life known very clearly to someone. This is the time for you and your child to work together and come up with what is the vision for their care, their life, their social life, everything about their life, to put it in one document in one place so that someone can step in immediately and know exactly what you were thinking and even what your child was thinking at the time when you drew this together. This is not a legal document. There's no legal obligation to follow this, but it's something that's super important for someone. If they need to step in and help support your child with a disability. I'm pausing again for questions. No questions. Okay, hopefully you're all you're all with me here. This is the meat of what we're talking about. This special needs trust. And I do want to make a caveat. So they're commonly referred to as a special needs trust or a supplemental needs trust. I got a note from a self-advocate last week, actually, and she wrote to me and she said that she thought it was not derogatory, but she thought it was a problematic description. And she said, why is it that people who have disabilities have special needs and everybody else just has needs? That's a very good point. The challenge I have is that everybody knows this is a special needs trust, so I am sort of continuing that conversation, but I'm trying to start to move to a better description of it, and it really is a supplemental needs trust. That's really what it does. It supplements government benefits. So that's actually probably a better description, but most people don't know it as that. So at least this point during the transition, it's still showing up as special needs trust. The special needs trust is that the advantage is that it allows your child to have money and still get government benefits. The disadvantage I have is that you need to hire an attorney and it needs to be drafted. Like I said in the beginning, the website that I'll introduce you to that I'm part of, the nonprofit organization, does this at a fraction of what it usually costs with an attorney. And I'll stop again, but we're going to get deeper into the special needs trust and why you need it and all that. So this is why you need it. If your child with a disability has over $2,000, they can no longer collect SSI. And if they have, I think many of you may have adult children with a disability on this. By a single dollar and they have $2,001 in their account, they can no longer collect SSI, at least for the time period that they have excess of $2,000. So what happens with this, how this works, is that if you want to leave money to your child with a disability, or you want them to be a beneficiary under your life insurance or your retirement account, your IRA, your 401k, or if someone wants to give them money in their will, if it's like your parents want to give money to your kid who has a disability, they can't leave it to that child directly. It has to be left to the trust. Otherwise, if they go over $2,000, they're not going to be eligible for government benefits. That's the crux. That's why we who have family members with a disability need to do this type of planning, because if your child has a disability and is collecting SSI or some other government benefit, it puts them in jeopardy of losing that benefit. Because I think I had a bunch of, well, no, I'm just gonna, I'll take questions and hopefully people have questions about this. No questions. Let me go to the next. So this is what people mainly think about when they, the solutions that they think about when they do this. One is to just give the child with a disability, your child with a disability, the assets outright. The problem with that is if they're collecting government benefits, that they will more likely than not lose those government benefits. If they're collecting SSI, which is supplemental security income from the Social Security Administration, they will definitely lose that benefit. The other thing that people say, well, I'll just not give them anything, which is, again, not a great solution, because they could have the benefit of these assets that you're giving your other children, and they should be able to get the benefit of those assets and still keep their government benefits. The other thing that people, and I hear this one a lot, is leave the property to another family member. Well, this money's for Johnny. He has a disability. I'm going to give it to his sister, Susie. She will always take care of him. And that's why I'm going to give her this chunk of money. I can trust Susie. She would never do anything that would hurt Johnny or to jeopardize his future. The problem is, I can walk you down the path. Susie gets married. Now she loses, then gets divorced, loses half of her inheritance in the divorce, or gets sued because of some accident or malpractice suit or whatever, and loses all the money that she got. So Susie ends up losing the money that she was supposed to be holding for Johnny. And we know her intentions were great, but it doesn't always work that way. The final choice and really the only choice is to create a special needs trust so that money can be left to that person with a disability in a way that protects the asset and then still allows that person to collect government benefits. And I'll pause again for questions.
Yep, so Fran has a question about SSI. And
Yep.
the 2K, Fran, did you want to ask the question?
Yeah, sure. Hi, Tom. I wondered about SSDI. So my daughter is on, special needs trust notwithstanding, my daughter's on SSDI now because of her dad had gone on Social Security, so then that bumped her into SSDI. And I know they told me that, the issue around her earning wouldn't necessarily reduce it, but I wondered about the Mass Health.
So it should not affect any of those. The only issue for Mass Health would be her earnings.
Mm-hmm.
So the SSDI does not have the same asset limitation of $2,000.
Yeah.
She does not have an asset limitation. So, their need to create a special needs trust is not so important for her because she can take all this money in. And I'd have to check on the actual, the only thing I know for Mass Health is the issue on income limitation. So, and I'm not sure what that is, but I'd have to get back to you on where those numbers fall. But there is obviously an income limitation on Mass Health, and then there's a declining scale to at some point as you move along using the connector for health insurance. So I don't have a good answer for you on that, but definitely the asset limitation is not a challenge when someone is collecting SSDI. And SSDI is Social Security Disability Income, for those that don't know. And SSDI is looked at as something that you paid in for. So someone paid in, her father had paid into Social Security. So essentially she's collecting her father's benefit that he paid in for. So it's not the same as supplemental security income. Supplemental security income is based on, you don't have to have paid in at all to get SSI. To get SSDI, someone paid in, whether it's that person with a disability or that person's parent paid in. And so that money just comes out without the asset limitation.
Okay, and the next question is, how do you deal with child as life insurance beneficiary?
So what you should do is you create the special needs trust, and then in the beneficiary, you leave the money to the trust for that person. And usually the language is, I leave this to the trustee of the Johnny Smith Supplemental Needs Trust for the benefit of Johnny Smith or something to that effect. So if you've done a special needs trust, what you should do is show it to your insurance agent and show them and say, I need to name the trustee under this trust as the beneficiary for the benefit of my son or daughter with a disability. Was that clear enough?
Yes, thank you.
Okay, and that's it for now.
Okay,
Can I ask a follow-up to that, actually?
sure. Yep.
Can you do a special needs trust? Can you put two kids in one trust, or does it legally have to be two separate trusts?
I would not. I think it's best to separate them. I've never done one together, and I've had multiple clients come with more than one child that had a disability. And what I always do is separate the trust so that they're separate trusts. I don't see, I don't know. I can't wrap my head. I guess you could do it together, but for me, it just doesn't make sense.
Not to, but
I'm sorry.
It probably makes sense not to. It just ran through my head as I'm talking to you and thinking about two different kids. Can they have the same? I'm sure you'll get to this, but the trustee, can they have the same trustee, or does it have to be two separate?
Oh, absolutely. Can have the same trustee.
They can. Okay.
Yes, yes, it just makes it seems to me cleaner if they have their own trust, because then they each have their own money, and otherwise it's kind of, I don't know. It does make sense in some ways to pull the money together, but it's something that I don't usually advise to do that. I actually advise not to do that, to get two separate trusts, one for each child.
Okay, makes sense. Thank you.
Any other questions?
Yep, one more just came in. Can the home property be left to the special needs trust?
Yeah. I want to just talk a little bit about that. Because I hear this a lot when they come to me and they say, oh, I want, Susie's, I want to make sure that the house stays here and that Susie gets to live in it. You can do that. You can put it in the special needs trust. I think the other thing to consider is there's other benefits that are available to people. Tom,
You're kind of going in and out a little bit on the
because I'm putting my hands as well.
Okay.
It's hard for me to talk. Better.
No, it's still cutting in and out.
All
right, how about now?
Beautiful.
Okay. Now I forgot the question.
Something with the house.
Even the house. Yeah. So you can put it in the special needs trust. But the other thing to consider is, your child is not going to stay the same through their lifespan, right? They're going to change and grow and have different needs. So it may not always be appropriate to think that they're going to want to be in the house. There's also a lot of folks with disabilities, if they have low income, can qualify for a Section 8 certificate so that they can get rental housing and paid for, 3/4 of it by the government. It's not always the great choice to leave the house to your kid. I'm sure it's the best choice for some families, but I would advise not to get stuck into that thinking is that the child should stay in this house that they grew up in. Talk to professionals, bring it up in when you're meeting, with Pam and Allison to talk about, well, what are some alternatives? If your child decides to live on their own in their own apartment, they can qualify for a government benefit. And so there's all sorts of other alternatives. So my only caveat for that is to make sure that you're giving your child enough flexibility and people enough flexibility. So as your child's needs and wants change, that they're able to accommodate that you don't need to think of the house as the one and only place that this person is going to be happy in, or it may not even be the best place for this person to stay in. But talk it over with family and friends and professionals, and particularly with your contemporaries. You know, if you're getting together in group, it's something to talk about. If you're comfortable talking about it, to see what other people are doing as well. But I think that a lot of people just think that that's the only thing that they can do and the best thing that they can do. And it's not necessarily the only and the best thing you can do. But the answer is you can absolutely do that and put the house in the special needs trust. Any other questions?
Says another thought is to leave the home property to the state with the understanding of adult child staying in home with caregiver.
Yeah, that doesn't sound like a great alternative to me, but it's, you know, that would be complicated, I think, would be complex. I'm sure it's doable. And it's one of the things to think about. I think what you would really, it's better. I don't think I would give anything to the state for sure. That would not be a good thing to do. But having like if you left it to your child's special needs trust, now they have a place to live in with very, low expenses in some ways. That could also be paid for out of the trust. And then have the, whether their child's getting services out of like DDS or whatever, have them provide the services in the house, but not, I don't think that's a good solution. I think that, I think we could probably spend a whole night talking about this, and maybe that's something we should probably do at some point. But I think this whole thought about doing that with the house, I think we need to do a deep dive in. And I know that didn't answer your question, but it's not something that I would advise for sure.
Okay, the next comment was better probably to leave the house to the estate than sell the house and use it to fund the special needs trust.
I think so, but that, you have to make your own decision. There's a complexity here with opportunity that's here. That I think would be the better solution, and still give your child a lot of flexibility. But I think it's something that really needs to be sort of vetted out. I don't know if I'm answering this question. A lot of these, maybe I'm coming this with my own baggage too, is the way that I think about empowering someone with a disability and what that looks like, as well as trying to take advantage of any government benefits that's there to make that person's life the best life that they can have. And I think sometimes if you limit them and tie them to the house, you're limiting their experience as well as the quality, depending on the house. But you're sort of limiting them to what they're doing. For instance, if the child decided to move into an apartment with a Section 8 certificate, they would, and say their income is only SSI, which in Massachusetts now is about $900, they would be responsible for, approximately $200 of the total cost of living there, including utilities and everything else. So now the child can live in a place for like $200, and it could be a luxury apartment. Or they can someone could be struggling on how do we keep this house going? with taxes and insurance and utilities and all that. How do we pay for all this? And that may not be the best choice.
Okay, the next one is, how many trusts do people actually need? One special need trust for the child, do another one for the sibling? Do parents need one as well?
So how this actually works, if you use the website and you had minor children, if your child with, let's say you have two children, Johnny and Susie. Johnny has the disability, Susie does not. When you pass away, say Johnny is 20 and Susie is 22. Under this trust, under the documents you would get through the website, Johnny's assets, it gets split in half. All the assets get split in half. Half goes to Johnny's special needs trust and half would go to Susie. But under the will, Susie would have her own trust until she turns the age of 25. The challenge is that it's typically not great to give large sums of money to someone who's like 18 years old. And the number that's used in the documents that you get under this is 25, because by 25, that person is going to at least have better decision making. Even the science now says that your brain doesn't fully form until like 25 or 26. So it's not a great time to give someone that age a lot of money. So the answer is, under the Susie and Johnny case, they both have a trust. Since Susie doesn't have a disability but is under the age of 25, her trust is actually created within the will, and it's just called the testamentary trust. And Johnny's gets his money into the special needs trust. And the trust is operated under a trust. You have a trustee who is the person that handles all the money, and they handle it and give the money out to the beneficiary, who is, the child, either Susie or Johnny. So someone can handle the money, or is at least asked to handle the money. And if they think that if the child doesn't have a disability and they're under the age of 25, they still have the power to give the money over to that child. That's let me see if there's any follow-up to that, and then I want to follow it up with something else.
Okay, we have another question.
Yeah.
That my mom and sister both have the child as the insurance beneficiary, as well as me and my husband. Do I need one trust for each of them or one for all of us?
You just need one trust for the child with a disability. So if they're going to leave money to the child with a disability, it has to go into the special needs trust, but you only need one special needs trust. You do the special needs trust, say it's the Johnny Smith special needs trust. So grandma and brothers or whoever's going to give the money can give the money to the special needs trust for Johnny. Did that answer the question?
Yes, very clearly. Thank you.
And Tom, I just want to let you know, I'm looking, it's about 7:22 right now. So
Are we ending in 8 minutes?
we don't have to end in 8 minutes, but I want to be respectful of your time. And I know
Yeah.
You want to show the website too. So
Yep.
yeah.
This is just going over so Massachusetts, the SSI benefit right now, or in 2023, will be $914 a month. So, and if the child is living on their own or away from their parents, it's a little less if they're living with their parents. Once you qualify for SSI, you're Medicaid or Mass Health eligible. The other thing just to know is that there's ABLE accounts. An ABLE account, you can donate up to $16,000 per year, and up to $100,000 is not counted against SSI. it's something that you can, and you're going to get this document, I guess. I'll send it to Pam. There's live links in the document that you can click on. This if you live in Massachusetts, to create an ABLE account, you can just go to the Fidelity website. The ABLE account is a great solution, but a good plan would be to have an ABLE account and the special needs trust. Because if you're going to end up giving more than 16,000 per year, and particularly an inheritance is going to be more than 16,000 a year. If you own a house or some asset, there's going to be more than 16,000. But it's another good tool to use. And let me just, any questions on the ABLE account? I'll just go quickly to I have to change my share. Let me just see this stop share. And let's say desktop. I don't know how this is going to work with this on. I did. Okay. Let me move this out of the way. I'm just going to. This is the website. Oh, hold on. I'm not in the website yet. This is just the website, and there's a few things that I'm just going to point out on the website. First is services. These are the documents that we had talked about: the letter of intent, healthcare proxy, power of attorney for educational matters. We didn't talk about; it's not so needed in Massachusetts, and the special needs trust. And then there's resources, legal terms, ask questions, a whole thing about ABLE accounts. And there's also a blog. And the blog is a whole lot of information in the blog. And you can also actually, once you click on it, you can actually search within it on any area that you're interested in. I've been writing a whole lot on this area, and there's quite a few. There must be like 20 or 30 at least blog articles on various components about what we talked about tonight. The biggest thing I want to point out here is under contact. Can you all see what I'm doing here too? This is all working, right?
Yes, it is. Yeah.
So one of the things is you can ask a question. You just click on it, you can ask a question. But the best thing, I think, that differentiate us from anything else, if you click on schedule a consultation, it just brings up a point where you can actually set up a meeting. And this is a completely free meeting. There's no obligation. I'm happy to discuss like things that we just talked about tonight or whatever, or any way I can help you in this meeting. Set up by video meeting, and then you just set up the meeting whenever you can make it. And it's all done automatically. And if you had a question before you use these documents, that's what you use it for. Or if you did the documents and you have a question after, you can use it then. And you can use it both times. It's just completely free time to talk to me and to provide the service. So that's critically important. Then I'll just go back in to just give you a quick demonstration of how. So special needs trust, draft your special needs trust. If you go through this process, what you end up with is a will for each, if you're married, for each spouse, and the special needs trust are all included in one document. It's important that your will leave the money or your assets to your child with a disability to the trust directly. And that's why the wills and the trust are created at the same time, because the wills are set up to leave the money for your child with a disability to the special needs trust. You just go through and answer these questions. Super simple. Are you married? What state do you live in? You just continue on. And so it's super simple. Your name, do you want to leave everything to your spouse? And then, so you just go through the process. Once you're done, you click on submit. It sends it'll then bring you up a page to pay. The cost is $500 for the 2 wills and the trust. And then the some of the other documents range from like $50 to $20. And then the letter of intent is free, as I had talked about before. So let me just go back to the. And then we're back here at questions. So are there any follow-up questions? I think I clicked the wrong button there. I want to stop sharing, but I
Nope, you
can't
stopped
see.
sharing. It doesn't show anymore. So I think you did it, what you wanted.
Oh, perfect.
Yeah. So
Great.
it says, so from Fran, I'm the trustee for a special needs trust for my daughter that unfortunately is being funded through life insurance through the death of a family member. What is the best type of bank account to open for a special needs trust? I know this isn't really a legal question, more of a financial one.
And I was going to say that. So I guess the best thing to do would be just talk to your financial advisor. And if you don't have a financial advisor, get one. You could also even talk to like Fidelity folks. But I think the best thing would be to get a certified financial planner and to go to that person to help you with that process. I really can't advise that. I have trouble with my own stuff. I have my own financial advisor because I can't be trusted to do my own stuff either. So, but to think about, it's someone that you can sit with and think about how long-term, you need this money to last, how much money it is, and a whole lot of other factors involved. So the best advice I have is to go to a financial person that you trust, that has some familiarity with special needs or not. They just really need to know what the financial needs are of your daughter, and then how long we expect this to be using this money and when we're going to draw from it.
Okay. Lisa says changes to documents. Can we change at any time without any additional fees, or what is the fee if there were changes?
So if you're going to change the document, you're really, there is additional fees to change the documents. So if you're going to go on the website, do the documents, you meet with me after you do it and you say, Tom, this is the story. I need changes to this document because you just did it, and we just talked about it. We realized that it wasn't what it should be. And that happens. That's all included in the cost. But if it's like 2 years later and it's time and you need to make a change, you can talk to me about how to best do that. And we can decide how to do it and move from there. But then there would be if we're actually going to draft something up, there would be a charge for that.
Okay. Is the special needs trust basically a savings account, or does the money have the opportunity to gain value over time? That's
It could be put, and
Yeah.
that was the question that Fran asked, essentially you have a chunk of money in this trust. You can invest it any way you want. It can be invested in anything. It can be invested in real estate, the house, or, mutual funds or stock. It can be invested anyway. That's a decision that the trustee makes about how best to do that, because that's the trustee's responsibility. And that's why I was suggesting to talk to a financial person to help you make that decision. But you're not stuck with a bank account. You can do this any way you want. The other thing just to point out is once you do the trust, you need to get a tax ID number for the trust, because the trust is its own individual legal entity. So once you have that tax ID, which I can help you get, the tax ID, you can go create open bank accounts, open an account at Fidelity or Schwab, Charles Schwab, whatever. Everything is reported through the tax ID for the trust, because the trust is its own legal entity.
Okay. Can we get individualized help with your organization to create will, trust for complicated situations, siblings, etc.
Yes. And that's what I was pointing out with the set up a time to talk to me.
Okay.
So that's how you would do that. Just set up a time and we can talk and figure it out.
Okay. And Fran says, thanks, Tom. This is so helpful. Really appreciate it. And Lisa says, thanks so much.
Great.
And Holly
Thank
says,
you.
okay, thanks. Getting lots of thanks.
Any other questions?
So I never know, Fran, is that a hand wave or a one that you have something?
Oh, no, that was an applause.
Applause. Oh, good. I got to learn my reactions. Excellent.
Right.
So any other questions for Tom? Oh, wait a minute. Here's one. Yeah, do you need a tax ID before the special needs trust is funded?
Yes. And the tax ID you can get it in a few minutes. You actually just go on the IRS website. If any of you haven't done that, you just go on, enter the information about the trust, and then you click a button and they immediately send you a PDF with the tax ID. So it's something that's not, it's actually takes minutes to get the tax ID.
Cool. Yeah, Dave says, thanks, Tom, very helpful. Fran said getting tax ID is very easy. And Deb says, so nothing is in the special needs trust until our deaths, though.
That's the best way, I think, to handle it. The only other choice would be if you have the only thing that's common is if you have your parents or the child's grandparents want to leave them money, like if they're leaving money, that's when you should have that set up and ready to go to do that, to accept the money. I think we're about
I
time.
think that's it. Awesome. Well, thank you, Tom. Thanks so much. Lots of
Thank you,
great
everybody. It was great to
information.
be here.
Thank you,
Great.
Tom.
Thank you.
Excellent. Thank you. Good night, everybody.
Bye, everybody.
Thanks for coming.
Thank
Good night.